Let's turn from there, speaking of justice, to another case that's our headline today. A landmark alimony judgment by the Supreme Court today. In a big relief that could extend for all Muslim women, India's top court today ruled that all married women, including Muslims, are entitled to maintenance from their husband after divorce under Section 125 of the Code of Criminal Procedure. What does this mean? Kanu Sharda has more details.
The Supreme Court today ruled that a divorced Muslim woman can seek alimony from her husband under Section 125 of the Code of Criminal Procedure. The judgment came as a bench of Justices B.V. Nagaratna and Justice Augustine George Massey dismissed a Muslim's man petition challenging a direction to pay his wife maintenance after divorce. The court today made it clear that the law for seeking maintenance applies to all married women irrespective of their religion and has held that the maintenance is not a matter of charity but a fundamental right of married women. The top court also said that some husbands are not conscious of the fact that the wife who is a homemaker is dependent on them emotionally and as well as in other ways. Time has come for Indian men to recognize the indispensable role and sacrifices made by housewives for the family. With camera person Nasir from New Delhi, this is Kanu Sarda for India Today.
What does this judgment mean? How will it change the lives of Muslim women in particular? We want an explainer to be done. As I said, we are slowly trying to move away from every debate becoming a shrill face-off. This is what we call our explainer section. Joining us now is Shaadan Farasat, advocate at the Supreme Court, and I'm joined by Zakia Soman. Zakia Soman is the activist who campaigned against triple talaq. I appreciate both of you joining us. Shaadan, give us your sense. What does this judgment mean? Does it mean upholding the primacy of, dare I say, secular laws over anything that is seen to be reflected to Sharia or a community-centric law? You're on mute.
Fundamentally,
yeah, go ahead.
It actually reiterates. Yeah, clearly.
Yeah, now I can.
So it fundamentally reiterates the existing position of law, which is that under 125 CRPC, Muslim women, even subsequent to divorce, have a right. So that position of law has existed under various judgments already. It reiterates that position to some extent. There is a certain aspect of interpretation on the 86 Act, which it says that those two.
Okay, we'll try and get our
They do
lines.
not override.
We're having a problem with your line, Shada. We'll try and get that fixed in a moment. Meanwhile, Zakia Soman is joining us. Zakia Soman, do you see this as, again, the Supreme Court, as Shaadan said, reiterating that the Supreme Court believes laws on issues of maintenance, on issues concerning the personal rights of women must be uniform and they must be gender neutral and above any form of religious law?
Yeah, but I would like to frame it a bit differently because the judgment here is reiterating the constitutional promise of gender justice and gender equality. Mention of maintenance to be given to a divorced wife in the Quran. It is the violation of this provision which has resulted in this situation. And also the resistance to reform in Muslim personal law, resistance to codified Muslim family laws, which has led to this kind of an impasse. And now I think we have come a considerable distance from Shah Bano in 1985 to Justice Nagaratna and Justice Massey now giving this judgment. And they're saying that maintenance is like a fundamental right. It's not a charity. And, there needs to be, we need to have this change in our mindset. The mindset of the patriarchal mindset, in a marriage when things go awry. The husbands, some of the husbands tend to think that they want to look for loopholes to escape the responsibility of providing maintenance to your wife.
Right.
So this provision already exists in the Quran. It's unfortunate that it could not translate into personal law because we do not have a codified personal laws. And I'm so glad that this judgment is addressing a long-pending need of the Muslim women, and it is enabling Muslim women to attain legal parity with other women, be it Christian women, be it Hindu women. in terms of maintenance after divorce.
Right.
So it's a very, very welcome and a progressive judgment.
The reason I'm asking you this, and Shadab, maybe we can look at chronology. You had the Muslim Women Protection of Rights on Divorce Act 1986 in the backdrop of Shah Bano. It became a huge issue where the Rajiv Gandhi government was accused of succumbing to extremist fundamentalist voices. Then you had in 2019 Muslim Women Protection of Rights on Marriage Act 2019, where any pronouncement of instant talaq was declared void ab initio and illegal. And there was up to 3 years in jail and fine for instant talaq. So from 86, where the state was seen to have succumbed, many believe, to extreme voices that were refusing to accept a codified personal law, to what happened in 2019 to now today, is this all progress towards gender-friendly, gender-neutral laws?
Oh, yes, the simple answer is yes, but I think it's more than that. See, you are right that the 86 Act was to undo the Shah Bano judgment under the Rajiv government then. But even the Supreme Court then, in its interpretation in Daniel Latifi and in other cases, had actually given broadly the same meaning which the Supreme Court has in fact reiterated today. But I think the real meaning of today's judgment is this. I think there is a whole part in this judgment in about how there has to be equal sharing of financial resources even in a normal subsisting marriage.
Right.
For instance, it should not be in India, the workforce participation of women is only 37%. So that is 37 out of 100 women capable of participating are participating, right? So you still have more than 60% of women as homemakers. And for them, financial independence means that there has to be a mechanism to share the resources, even in a subsisting marriage, not just in a marriage which has gone awry and there's a divorce and there's a question of maintenance. For instance, joint accounts. There's a discussion on how they should be joint accounts and the wife should have continuous access to financial resources in consonance with her dignity. She's not dependent. It's important that a man realizes that if he's the one who's providing the finances and the wife is taking care of the home, then the finances are available to wife in a dignified manner. I think these kind of discussions which are there in this judgment are new in the sense that they are very nuanced. They understand a functioning of a family in the Indian context very well. And it's therefore to that extent a completely new addition.
So does it stretch? So you're saying it stretches across the community divide. It is making it's making a principled point that a woman is entitled to maintenance, whether Hindu, Muslim, doesn't matter.
Yeah.
They're looking at it, therefore, isn't it therefore a step towards what I said, gender neutral laws?
Gender neutral and the concept of family and the responsibility in a family of both the husband and the wife, especially when the wife is not earning. And this is even in a functioning marriage, right? So it is really to that extent very progressive, but it goes beyond the classical judgments, which are in the context of divorce. I think the judge, the concerned judge has really made an effort to actually realize the day-to-day realities of an Indian marriage and how it works on the ground and try to address that head on. And I think from that perspective, it's very, very progressive and it's very welcome.
Zakia Soman, as I said, the chronology suggests that the law is moving with the times in a way to ensure that family rights, protection for the woman are given a certain primacy, which perhaps in a more patriarchal system they were not earlier. This is trying to break away from those patriarchal stereotypes and recognize the woman's rights.
Yeah, definitely. And there is a lot of awakening and consciousness within the communities also. Not only the women who are much more aware about actions of the community also recognize that women should be given their rights, granted by the
We're again having some problem, ma'am, with your audio. We'll try and fix that. But I'm going to, in conclusion, ask you, Shadan, how does all of this, it's very interesting that I haven't heard any opposition even from the usual suspects, whether the All India Muslim Personal Law Board or those clerics who in the past have sort of questioned the manner of whether courts can intervene in this space. It seems that there is a willingness to accept, therefore, that women married under Special Marriage Act will get these benefits. And if a woman has been divorced in a valid way, she can move either under the previous act or she can move under Section 125, and they've accepted it.
Yeah, so not a special marriage act. This was a case of a normal nikah, which is under personal law
Right.
itself. So even under normal, you are right. I mean, so if 30 in from 1986 there was mass protest over the Shah Bano judgment. Today we are not seeing any of that, and that's welcome. And that's the way it should be. Everybody should learn to see the things as that should be. And I think it's quite good that there's acceptance. In fact, I would go so far as to say that not just there should not be any opposition, but even things like AIMPLB should actually, frankly, welcome a decision like this. It will also improve their position in the society of what kind of organizations they want to be seen at, as not just somebody who is in that sense trying to stop change, but also welcoming change when it's actually in the interest of equality, it's in the interest of gender justice.
Okay. I think we've heard perspectives that reflect the fact that this is an important step forward again in gender justice. Yes, Zakia, you're back with us. You want a quick minute on that? Do you feel that with every such judgment, women feel more and more strengthened?
Definitely, definitely. And also the community is changing. The women are changing, the community is changing, and there is no more that kind of sole reliance on the conservatives. The conservatives are getting somewhat irrelevant. I might make bold to say that. And there are enough number of sane voices within the community who understand the nuances involved in this kind of a situation. And there is overall a consciousness and a demand for change. And these judgments are going to encourage that kind of those kind of developments.
Let's leave it there. We've heard two voices to try and explain this judgment that effectively means that all women have that right to alimony, including those who've had a nikah under Muslim laws. They too will be entitled to these benefits. Shaadan Farasat and Zakia Soman for explaining that judgment and its importance to us. Thank you so much.